Hello and welcome to the first RGE Knowledge Bites for Business webinar of 2021. Happy New Year, everyone. I'm Sarah Hillier and I'm the Head of Business Development at Robert Gordon University. When we first launched RGE's Knowledge Bites for Business last summer, we certainly didn't think that we would be in another full lockdown running these webinars from our home in January. However, I'm delighted that we're still seeing so much interest for our live webinars, as well as a high number of visits to our Knowledge Bites for Business webpage, where we're regularly adding new content. So if you've not been there recently, I'd encourage you to go and have a look. There's some really interesting videos and articles there, which I hope you'll all find useful. Knowledge Bites for Business allows us to share some thoughts and insights from RGU's community of experts, which we hope will be helpful to you now and also in the future. We're very keen to hear from you because it's important that what we present at these webinars and also share on the Knowledge Bites for Business is what you're looking for and helps you with both individually and within your business. So please let us know if there's any topics that you'd like to hear, because I'm sure across our community in RGU we'll have someone that has some insights and knowledge that they can share on that. So before we get started with today's discussion, I just wanted to run through some housekeeping to ensure we all have an enjoyable session. Your mic and camera should have automatically been switched off when you joined the meeting, and we ask you keep them this way so that we have an enjoyable session for everyone. Please ask questions throughout the session using the Q&A facility at the bottom of your screen. I'll then pose the questions to Andre at the end of his presentation. Please don't share any personal data though, apart from your name and company, as the session will be recorded and will be available on the Knowledge Bites for Business pages next week. Check that you signed in using your full name rather than the nickname so that we also know who's all joined us today. And from looking at the attendees list, I think everyone's done that so far, so thank you. So, right, enough from me. I'm now going to hand over to Andre Kotelnikov, a lecturer from our law school, who's going to share some insights into dealing with customer disputes online, a topic which I'm sure is becoming more and more prevalent to all of us. So thank you, Andre.
Yes, thank you very much, Sarah, for this introduction. And hello, everyone. I'm really glad to have so many participants with us today. I see some familiar names on the list, and I'm really glad to see you. Hello, everyone, and colleagues and friends. Those whom I haven't yet met, hello, and thank you very much for joining just as well. Just to add a couple of housekeeping things, this seminar will be recorded, and you'll be able to find the video on webpage of RGU Knowledge Bites for Business in a week or so, I understand. If you have any questions during the presentation, please use the Q&A function. You could do it a bit more interactive, but due to the number of participants, it's probably best to keep it that way. And I'll do my best at the end to answer all the questions, if I can, with Sarah's and Claire's kind assistance. If you'd like further discussion, I will put my email address on the last slide. Please do feel free to get in touch. So let us begin. The idea of today's webinar is to see how companies around the world are dealing with customer disputes utilizing the advances in technology. There have been many exciting technological developments recently, and I approach those as a mere lawyer. For a scientist or a management scholar, there are, of course, further layers and layers of complexity in this topic. Among lawyers, there is now quite a serious discussion about whether or not the AI will eventually put us out of business. I would like to address a narrower issue today, whether the two technologies in particular, the AI and the improved communication technologies, have the potential to bring the two existing professions, customer service and law, closer together. I do so without claiming an ultimate expertise or knowledge of the future, God forbid. Instead, what I can do is just trace some tendency and wonder where this might lead us, maybe initiate a discussion. During the webinar today, after this brief intro, I will address three broad issues. First, the use of technology in customer service. Second, the use of technology to aid the resolution of disputes. And third, and finally, how technology is changing the life of a professional in customer service and in law. And our central theme will be this. Currently, there are two distinct professions and two distinct areas of expertise. One is dealing with customer complaints for a company that offers goods or services, whether it's business to business or business to consumer. And the other profession is dealing with legal disputes, particularly with contentious business in courts of law. These two fields of expertise generally know and care very little about one another. However, I submit that there is a tendency for the two realms to grow closer to each other. And perhaps in the near future, we may see that tendency increasing. The next slide, please, Sarah. Yeah, thank you. It's always nice to begin with a story. Donohue and Stevenson was a Scottish case that reached the House of Lords in 1932. The majority decision in that case, particularly the opinion of Lord Atkin, laid the foundations of the modern law of negligence. So it's hard to think of a better known case in the whole common law system. The facts of the case were simple. Mrs. Donohue drank a bottle of ginger beer and then found out a decomposed snail was in the bottle. Next, she didn't visit the manufacturer's website. She didn't contact the customer support or anything like that. She went right away to sue Mr. Stevenson in the court of law. The case went to trial. There had been appeals, and I'm sure the lawyers for both parties were quite happy about it. All that was happening a little less than 100 years ago. The question is, how would a similar unpleasant situation unfold today? And how would Mrs. Donohue and Mr. Stevenson go about their little misunderstanding in 10 or 20 years from now? And next one, please. You see, the decision of Mrs. Donohue to go directly to court was hardly surprising or unusual. In Victorian times and early in the previous century, there normally had been very little territory, so to speak, in between businesses and the courts. If customers were unhappy about a product or a service, they could complain to the shop owner, the business owner. If that didn't work, customers faced a choice: either let it go or hire the services of a solicitor and start a legal case. Next one, please. In the 20th century, things changed a bit. Companies acquired customer service departments with functions such as customer support and assistance with routine queries. But importantly, they also deal with customer complaints. Businesses have realized the importance of resolving customer complaints early. To name just a few advantages, it helps to build a brand loyalty. It acts as a free feedback channel about the performance of departments and products. It prevents disputes from escalating and thereby saves costs and so on. On the legal side, the 20th century has seen a growing dissatisfaction with courts as a method of resolving disputes. And as a result, we saw a rise of alternative out-of-court methods of dispute resolution, such as, for example, mediation. These methods are often administered by non-lawyers, such as subject experts. But despite those developments, the divide between lawyers and customer service experts still remains quite significant. Next. Let's now turn to some of the fairly recent technological developments that came around more or less in the last, say, 10, 20 years to assist in the stressful work of customer service agents. Well, one exciting practical application of technology was artificial intelligence. And it was in particular, the use of chatbots in customer service. Well, in simple terms, what is a chatbot? Simply, a chatbot is a text or a voice-based interface that lets users execute certain actions and retrieve information using language. The chatbot can be deployed on a website, on a social media platform, on an instant messaging app, such as WhatsApp, and so on. In its most rudimentary form, there are bots that merely lay a chat interface on top of a simple service, and they just react to simple phrases and words, such as they understand yes, no, menu, and so on. At the other end of the spectrum, though, there are chatbots built as fully capable AI virtual assistants, like a few years back had been the case with Facebook's M. The ambition with that kind of technology had been that it could substitute humans altogether. So you could have a customer service completely composed of AI. Some experts predicted that by 2020, 85% of customer interactions would be handled without a human agent. Well, that didn't quite play out that way, I think. It seemed to make sense as a matter of making customer services more predictable and reliable, and to save on costs. In addition, the results of one survey, an interesting survey in particular, have shown that 72% of millennials believed a phone call is not the best way to resolve their customer service issue. These millennials preferred to solve their own customer service issues, turning to self-service solutions, including frequently asked questions, forums, and online chat or bot services. The customer satisfaction with such tools would vary according to individual preferences and traits. In particular, it is novelty seeking and the need for human interaction. But overall, the uptake could be significant and had the potential to increase over time. Next one, please. Next slide, please. Well, chatbots may still sound like an exciting new development, but actually the peak of interest in business application of chatbots was around 2016. Back then, it was seen as definitively the future. So many large companies rushed in to get their own AI-enabled chatbots. The chatbots had been expensive, so usually beyond the reach for small and medium enterprises. However, the post-2016 period saw some disenchantment with the technology. For example, Facebook scaled back work on its virtual assistant, M, after revealing that M had failed in handling 70% of all user requests. Google also admitted that it used humans in call centers to make its assistant work. The funniest story perhaps is about Microsoft's Tay, a chatbot that was supposed to be working on Twitter. And it was a short-living chatbot. It had to be scaled back and shut down in March 2016 after it started expressing some troublesome political views. So it only had been on Twitter for less than 24 hours altogether. Early chatbots often failed because they couldn't understand user requests. There was an almost endless variety of questions that users could ask, and that created a virtually impossible task for the bot's natural language processing abilities. The fatal flaw of early chatbots' super projects was expecting too much too soon. All-purpose chatbots that tried to handle everything often ended up doing nothing particularly well. However, this is not to say that chatbots are now merely a thing of the past. Actually, quite the opposite. Just last week, I interacted myself with the Amazon chatbot when I needed to cancel an order, and it seemed to work quite well. And I noticed I never had been invited to submit a natural language query. It only gave me a list of options. But there are useful chatbots today, and where they work, well, they usually operate in fields like law, health, and banking, fields that all run on highly specialized yet constrained vocabulary and documentation. They have become considerably cheaper as well. The cost of building a basic chatbot for a business may currently start from around £1,500, of course, with extra options increasing the price further on. Well, yet another field where AI is proving useful, and perhaps maybe more useful than a standalone chatbot, is, well, on this slide now, is helping human operators work more efficiently. Systems with AI embedded in them can monitor a nearly infinite amount of website and in-app activity for various indicators, identifying customer experiencing issues and who is experiencing the issues and what those issues are. An interesting example is voice analysis. So here on the slide, you'll see a screenshot from a system called Cogito. It performs live in-call voice analysis to augment behavior in real time and thereby create better human connections between customers and the agents. You see here, there is an example of an agent speaking with a customer, and the system gives them a clue in real time. Show some empathy right now. So the system is apparently quite efficient in detecting emotions and suggesting appropriate responses. The next one, please. Right, now what's been happening on the legal side of things? Let me just first have a look at the historical developments very quickly that do not involve technology as such. Next. So the courts of law, as of now, do remain at the top of the system, dealing with all sorts of disputes. However, the public dissatisfaction with them has grown in the 20th century. The number of cases courts had to deal with has increased dramatically, and it had become nearly impossible for the courts to be a primary resolver in all situations. Cost and delay involved in formal litigation are particularly often criticized. There have been numerous reforms, but all in all, those problems do remain of cost and delay. And next, to supplement the court system and deal with particular kinds of disputes and statutory schemes, there is now, well, at least in most common law countries, a system of tribunals. In the UK, as an example, the evolution of tribunals was in the beginning a bit haphazard. They were usually meant to be administrative authorities dealing with specialized fields. Like courts, they utilize an adversarial process. But the idea was that before going to court, parties had to try to resolve their case in such specialized administrative bodies. And over time, this resulted in more than 100 of different tribunals in the UK, each with their own rules and specific features, specific procedure. Then the system has been streamlined. Now there is, in fact, a whole system of formal justice, which is subordinate and supplementary to the courts of law. The most well-known tribunals include such bodies as the Employment Tribunal, Immigration Tribunal, and so on. Next. And finally, one further step down, so to speak, from the formal processes in the courts is the network of ombudspersons. Some of these schemes are voluntary, some have a statutory basis. Well, an ombuds, in simple terms, is an official dealing with complaints of someone small, such as a consumer, against someone large, for example, a company. Unlike courts and tribunals, ombuds procedure is largely inquisitorial. It can result in an investigation and publication of any adverse findings, or sometimes financial penalties against the company. A notable example is the Financial Ombudsman Service in the UK. It deals with the complaints against banks and other credit institutions. The Financial Ombudsman Service is remarkable also from another point of view. It has been a pioneer in dealing with the complaints online without any need for any hearings or representation. Well, since the current pandemic began, the other two tiers of the system, courts and tribunals, have also moved towards resolving the disputes online, with a particular emphasis on video conferencing, usually. Next slide, please. Now, moving on to alternative dispute resolution. This is an umbrella term for the various approaches to dealing with disputes outside the formal court system. And a well-known example of a successful ADR system is eBay. Essentially, it provides a platform for buyers and sellers to resolve their mutual complaints by negotiating with each other. And sometimes the platform itself intervenes. In that way, it successfully resolves around 60 million cases every year entirely online. Next one. A very interesting model has been in operation in British Columbia for a while now. The Civil Resolution Tribunal blends the features of a state court or tribunal with ADR methods, and the whole procedure is conducted online. The first step for someone who has a complaint is to explore the relevant information on the tribunal's website and use the online self-help tools. This is followed by direct negotiation and then mediation. And if those procedures are unsuccessful, then a judge makes a final ruling in the case. So all of those steps are conducted online. The procedure is seamless, one-stop single process. This model is highly regarded internationally. In the UK, the recent report by Lord Justice Briggs proposed the creation of an online court broadly along the similar lines. Next one, please. In aviation, as another example, we have seen lately a lot of disgruntled customers whose flights have been delayed or cancelled, and the air carriers struggling to keep up with the evolving pandemic. I teach a module at RGU on dispute resolution. And every year I ask students to do a simple exercise. I ask them to go online and find a body or a scheme dealing with ADR. And in the previous years, I was getting all sorts of answers, but it was never anything to do with aviation. Now, this time around in October 2020, I think half of the students in my class pointed out independently from each other the ADR schemes dealing with cancelled flights and so on. In this sphere, there have been two models, as far as I can see. One involves a well-known, reputable ADR body, the London-based Centre for Effective Dispute Resolution, or CEDR. They have adopted a special scheme for such cases. So British Airways, for example, joined this ADR scheme. The other scheme, Aviation ADR, is newly created and specifically tailored to this kind of disputes. In both cases, there is no fee for the consumers, only a possibility of small administrative costs if the complaint is unsuccessful. The system involves a simplified form of adjudication. And I think it's quite understandable that in view of the current situation, the aviation sector made further steps, voluntary steps, to provide customers with additional methods of recourse. So such steps that are short of a formal court process or even short of a formal complaint to an ombudsman, but go into a third independent party outside the company itself. It is valuable for a customer to have an intervention of the neutral third party. The procedure is confidential and there is no reputational risk for the company. Next. To look at another example, we see somewhat similar approach with the mediation scheme established by the Royal College of Veterinary Surgeons. It is designed for complaints about veterinary clinics with which the college cannot deal themselves on the basis of their statutory powers. And the related development, mediation lately is also moving, or generally mediation in all sorts of areas, is also moving online more and more. It had been quite unusual until 2020, but now when the parties and mediators had to embrace the technology, particularly video conferencing, there are many positive reports around about the success of online mediation, telling them how good was the experience and how they have achieved the very good results. So I personally have seen quite a few reports on this front. Next. Now turning to the profession of a lawyer and the various technological developments in this sphere. Well, law is often perceived as very traditional discipline. You can hear law students say that they have to study a lot of 17th century English cases, which is true, in fact, they do. However, there are a few interesting legal innovations around, particularly those involving the use of AI. And on this slide right now, there is one example, the app called Do Not Pay. It started off as an automated system for contesting parking fines and have since evolved in a few other related fields. Essentially, what the system does is it asks you a series of questions, prompts you to upload documents and so on, and then helps you to contact the relevant complaint center or a tribunal. The process is automated and there is no human lawyer or legal advice involved, as there is an excerpt from their terms and conditions on the screen, or at least as they were as a few days ago, and it stresses there is no lawyer or legal advice involved. So it is a machine service in essence. Next. Which prompts a question: can an artificial intelligence, as the matters stand now, argue a legal case? There have been attempts to create an AI that could produce a legal argument and present it to a decision maker, such as a judge. And that was showcased at the conference a couple of years ago. Those on the slide are the parties involved in that fictional dispute. And while the computer made some sense, a lot of sense, in fact, the judges have been unanimous that the human advocate sounded, for now, a lot better. Next. And finally, an interesting application of the AI technology to legal profession involves the systems capable of predicting the outcome of court cases. They take into account a large number of variables, and as a result, some of them, one example is Lex Machina, pictured on the slide, already today predict the outcomes of real-world court cases with greater accuracy than human experts. Next. So to sum up, next slide, please. We have seen today that lawyers and customer service agents are currently two worlds apart. And we also saw that the recent developments are moving them closer and closer together. Is that a sign of convergence or perhaps a wider process at work? Next slide, please. And the last. I would say that the two technologies in particular, the AI and communication, have the potential to bring the two existing professions much closer together. Returning to Donohue and Stevenson, Mrs. Donohue's complaint about a snail in the bottle would go a very different route today, certainly a more complex route. Both professions essentially have to deal with the same problem, only the means had been, until now, very different. But the tools begin to appear more interchangeable. An online mediator, for example, could definitely benefit from a live voice analysis like the one the Cogito delivers, or a customer service representative might definitely welcome a live AI assessment of a customer's prospects in a court of law, should the claim escalate to litigation. And now there is a lot of middle ground between the two poles. Not only there are courts of law or informal discussion with the business to deal with customer complaints, but there are also in between tribunals, ombudsman, mediation, conciliation, online dispute resolution. And much of that can be conducted without a traditional face-to-face meeting. The sole privilege of the lawyers, the nuances of civil procedure, is now often unnecessary in the simplified modes of dispute resolution. So now may be a good time for both customer service experts and the lawyers to start keeping an eye on the developments in each other's areas of expertise, because the synergies and the opportunities to benefit are already there. Well, nobody can predict the future, but the future does seem exciting. Well, that's all I had to say for today. Back to you, Sarah. And if there are any questions, I'm happy to start the discussion.
Thank you very much, Andre. That was a really interesting presentation, and I definitely learned lots myself. I think the whole world of AI and robotics is both exciting and slightly terrifying at the same time. And you know, hearing that you could be told by a robot whether you need to be a bit more empathetic is a bit scary, but could be quite useful for some people, I think, as well.
Oh, yes, just to be sure. When I was reading about it, I thought I could use that myself sometimes.
I think maybe when you're having maybe more of a challenging discussion with some people, particularly online, and just to remind yourself to calm down, or that voice in your ear is always quite helpful sometimes. But
certainly, yes.
So thank you again. Just to remind everyone, if you do have any questions for Andre, if you just want to pop them into the Q&A function at the bottom, and I will ask them over the next wee while. So I just wanted to start off, Andre. Obviously, you touched on it in your presentation that I think we're seeing more online dispute resolution now, you know, in 2020, and I'm guessing that a lot of that has been a result of the pandemic. And do you think that that's sped up the move to online dispute resolution? And do you think if there hadn't been the pandemic, would we, you know, would it be a few years until that actually took hold?
Yeah, thank you, Sarah. And I think this is a fair estimate that the pandemic has been quite tragic, in fact, quite unpleasant for all of us. But on the other hand, what it has done, was the pandemic accomplished, is it has been a massive learning event. Just a year ago, I was when I'm teaching some courses online, and I often came across people who knew in principle what video conferencing was, but had no trust whatsoever in the technology. And not only students, but also the professionals had so many opinions that it could never work. But now people have been made to utilize those tools. We had no choice but to try. And having tried, we quite surprisingly discovered that not only there were drawbacks, but there were also the advantages of electronic communications. And there's new projects popping up all the time. Well, one particular very interesting project is one by Professor Richard Susskind called Remote Courts. So there's an entire website devoted to how the courts are going online. Right. And there is a lot of exciting development going on there. So what the pandemic has done, it has accelerated the technological process a lot, not only by introducing technological innovations, but changing the state of mind of all the actors involved. What we previously believed was unthinkable now is kind of routine practice. Mm-hmm. So yes, there is a silver lining everywhere.
And I don't know if this touches in your area, but just thinking about this, are we seeing this in other areas of law as well, like criminal law and things like that? Are you seeing more sort of trials go to being resolved online?
Well, there is some move toward in that direction, but I mean, I'm not entirely sure this is always the case, but there is a perception that criminal cases are more serious. So if something is going wrong at the experimental virtual hearing in a criminal case, somebody could go to jail for no good reason, or somebody could walk free, although they shouldn't have gone free. Mm-hmm. So it's perceived that the stakes are higher. They are not necessarily always higher, because there are as well minor civil cases, minor criminal cases, and there are enormously important civil cases when somebody could lose the entire fortune or lose their house or something like that. So comparatively, it's not always the case, but generally there has been this perception. And maybe for that reason, the adoption of technology on the criminal side of things is a bit slower right now. So the ADR, international arbitration in particular, has been very quick to move in to produce new protocols. There have been cybersecurity protocols, by the way. Last year, has done an amazing job in looking in all the various aspects of which people had generally the perception of them being an obstacle. But there is no equivalent of the same ease with the criminal courts. So I would say the criminal courts for now are a lot more cautious than the civil courts, and way more cautious than the ADR providers. Mm-hmm. So yes, I think we will get there as well. If I try to predict the future again, well, it's there, it's on the cards. The criminal courts will get there as well. It just probably takes some time, trial and testing, and this trial and testing begins with the ADR. It's being rolled out in the civil courts, and then I think it will reach the criminal courts eventually. This is, I think, it's not just a possibility, it's probably inevitable that it will.
Mm-hmm. And do you think there are any circumstances where ADR would not work?
Well, certainly, yes. There are some areas where you need to have a court ruling. And there's actually, in the theory, there is an ongoing debate about whether ADR, the current move towards ADR, is a good thing. As a matter of state policy, we are seeing more and more ADR each day. Every day we speak, there is a new statutory scheme popping up, or a new voluntary scheme, or a new method being introduced in trial. So there's a lot of development in this direction. And the courts and the governments in all over the world are clearly in favor of ADR in the vast majority of cases. Although in theory, starting from maybe 60s and 70s, there has been a dispute going on in literature. And the scholars who argue that the settlement or the informal justice isn't appropriate, they put forward the arguments such as, well, there are some cases where you need to develop the law. Without a binding precedent, the law wouldn't develop, particularly in the common law system.
Mm-hmm.
And ADR is confidential, there is no binding ruling, the law does not develop. Or there are situations where there is a very gross imbalance of power. Say in mediation, for example, there is one, say family cases are said to be particularly suitable for mediation, with one big exception, well, a few big exceptions, one of them being cases involving domestic violence. So if there is domestic violence, they say the usual approach is that no, mediation is not appropriate here. The case is better, should better go to court. Or sometimes there are cases when there are interests of a third party involved who is not present at the negotiation table, at the mediation session, or on a Zoom call with the mediator, for that matter.
Mm-hmm.
So there are limited numbers of exceptions. But overall, if you look at the number of cases that could go through some online ADR option and those that couldn't, and you can see that the number of cases that get exempted is a lot smaller than one could suspect. Actually, a lot of court business in many countries right now are very simple, routine cases, often even uncontested cases. This is one of the areas, by the way, where AI might do quite well in the role of a judge. This sounds scary for now. Sounds like Terminator coming over and asking for your boots, your clothes, and your motorcycle. But actually, it may be the way that the world is heading right now for the simple cases, uncontested cases at least. So as long as the exceptions are carved out carefully enough, I think this the promise of ADR is quite high. And as I was trying to show, particularly in the disputes involving businesses to consumer or businesses providing a service to another business, those methods work pretty well. And probably even now the cases, a lot of cases aren't reaching the stage of a trial. Even right now, there's a UK and the US statistics say that even cases that do start in a court, 90% of them, or more than 90% of them, never reach a trial, because the parties negotiate and settle the case before it goes to trial.
Mm-hmm.
And some numbers are sometimes more dramatic than that, even more than 90%. So all those cases that do settle can settle just as well out of court. And if they settle at a later stage, they might have settled earlier, just at the point of a complaint. So if we seem to be having the developments in this area, if there is a sophisticated system starting from a complaint and ending somewhere at the door of the court, then there is a great chance that the dispute will never reach a court, which is probably a good thing for all involved.
Mm-hmm. And imagine it saves a lot of money from
Yes.
both parties. Do you? You've talked about if you could predict the future, and I guess, working within the law school where, looking to attract students to come and still study law. Do you think, there's still going to be a role for, our students who are currently studying law, but what they're studying now, will that still be relevant in the next 5-10 years, or are things going to move really fast now? And what would be your advice for someone who's considering law right now?
Well, it's one of those questions, and thank you for this, Sarah. I think it's a really good question. One of those questions where it's really hard to predict. But in all honesty, I would advise people who are interested in law to go ahead and study the law from the start, even now, even with the development of the machines and all sorts of innovation going around. And that is because the developments we are seeing right now are still dependent on somebody carving out. We have seen that standalone chatbots and standalone robot lawyers don't actually work so well. And even in some of the methods involving AI, for example, there is a particular method about the disclosure of documents in the courts of law, when you need to go through tons and tons of electronic information and figure out which part of that information is important for the case, which part should be part of the case file. So in that respect, AI has been helping the lawyers a lot, because it can handle large, massive chunks of information very quickly. But in order to do that, to check the documents for relevance, an AI has to be taught and it has to be controlled. So even then, there is a direct dependency between how well the AI is taught for a particular case. It depends on how, if it is taught well, it does a great job. If it's not taught well, not so much. Mm-hmm. So somebody with an understanding, starting from 17th century English cases, somebody is showing the system what sort of materials are important, and this someone will definitely be there. But also, the legal profession itself, I think, is changing slightly. I know that for some potential students, the attraction of the legal profession is that they are, if you saw the serious suits, so if they think if they get into a legal profession, they will be wearing a tie and they will be going around acting well, the way they act in the series.
It's a very glamorous profession, I have to say.
Certainly. Yes, and that image might be changing somewhat. But this is not to say that the legal profession as such disappears. I think it transforms. Transform is, to my mind, a better way to say it. But yeah, I think for now, if you like law, please do go ahead and join RGU if you fancy. That would be a really good choice. And yeah, seriously, go to a very good law school and get your diploma. It will be useful.
And I guess, and I'm sure, the courses will be adapting and also, just adding in more information about technology and, how to use that, and, just those additional skills that will be required by so many professions going forward as AI and robotics are introduced.
Yeah, there are skills that you have to learn as a law student these days. So we, for example, last year I taught online dispute resolution, so about the methods that work entirely over the internet. We have the innovative module on legal technology. So there are all sorts of things that law graduates should know, or at least those will be helpful for them to know once they graduate. So there are the role of technology in the whole kind of arsenal of skills is growing, but there has to be a law in it as well, a lot of law in addition to technology.
And then if here we've got a number of different companies have joined us on the call today, and if a company has a dispute with someone or another organization and is keen to look at how they can resolve that online, what would be your advice to them? How, who should they contact? Do you still speak to your own lawyer, or do you go online to search for different products? This is probably coming from a very simplistic view and not knowing much about the area. What would be your advice to a company who's looking to do that? Well,
going online and checking the options would probably best these days, because there's you see the old films when they say if the parties fall apart and say I'll see you in court. Well, not really. Actually, these days there's between the disagreement stage and the court stage, there's so many stages, and as I said, it's not probably not a court, but probably a tribunal. And before the tribunal, there will be an ombudsman, and you should try, in most cases right now, a mediation or some other form of an ADR. If you turn that, well, there is a case law in English courts, very famous case law, in fact, saying that if the parties haven't tried the ADR methods, in particular mediation, if one of the parties has unreasonably turned down an offer to mediate, they can be penalized in legal costs. And legal costs is a very serious sanction if you win the case, but lose on legal costs, it might be a Pyrrhic victory very often. So without, even now, I mean, this is what we teach students now. Meeting in court may never happen. The party should always start with small steps. Right? Contacting a lawyer would probably still be best. Lawyers will have the best legal advice, and please don't take this general thought as a legal advice. But yes, certainly there is not going to be court process at all in the beginning. A lawyer is very useful. Lawyers as representatives, as advocates, have a very useful role in other methods, in tribunals, in mediation. You could have mediation with lawyers. They are quite beneficial often. In other ADR methods, you could have legal assistance, but just don't expect to end up in the court of law anytime soon. It is a road, and you may get there or you might not.
Mm-hmm. Great, that's really helpful. Conscious of the time, Andre, so I think we'll maybe bring that to a close today, but just like to thank you again very much for your very interesting presentation. It was definitely very helpful, and thank you to everyone who's joined us today. As we said at the beginning, this will be available on the Knowledge Bites for Business web page next week. And just to make you aware that our next Knowledge Bites for Business, and just double checking the dates, is on Wednesday the 27th of January, and will be focused on post-pandemic tourism, which I'm sure I'm certainly looking forward to learning more about, and hopefully there will be plenty of tourism taking place later this year. So more information can be found on RGU Knowledge Bites for Business, and you can register there. And just thanks again, and I hope everyone enjoys the rest of your day. Thank you.
Thank you very much.